3, 2, 1, start.
It was contended before the two-judge bench that when this court had directed to file the award in this court, an application for making the award rule of the court is to be filed in this court, for this court alone has the jurisdiction to pronounce the judgment in terms of the award. In this regard, the decisions in Bharat Coal Limited versus Construction and State of West Bengal and others contractors were placed reliance upon. Resisting the said submissions, it was urged by the appellant state that if the court decides the objections to the award, the party will lose its right of appeal. It was also contended that by referring the matter to arbitration, this court had not really retained control of the proceedings of the arbitrator. To bolster the said submissions, heavy reliance was placed on State of Rajasthan versus Now Bharat Construction Company. The two-judge bench perceived the difference of opinion with regard to the entertainability of the application before this court and directed the matter to be placed before the Chief Justice of India for appropriate orders. That is how the matter has been placed before us. We have heard Mr. Ajit Kumar, learned senior counsel, for appearing for the appellants, and Mr. Rajesh, learned senior counsel, for the respondent. It is submitted by Mr. Rajesh, learned senior counsel, appearing for the appellant state that the view expressed in Guru Nanak Foundation Supra does not state the law correctly, and it will be inappropriate to annul the right of appeal of the appellants solely on the ground that this court, on the consent of the parties, had accepted that the award shall be filed before this court, and therefore this court alone has the jurisdiction to decide the objections for making the award rule of the court. According to Mr. Learned Senior Counsel, the definition of the court under section 2C of the Act has to be appropriately appreciated, and on proper construction of the meaning of the word court, it cannot be said to include the Supreme Court. It is additionally propounded by Mr. Rajesh that under the scheme of the Act, the appellants are entitled under law to file the objections before the sub-judge whose order is assailable in an appeal before the High Court under Section 39 of the Act, and if this court becomes the original court for dealing with the objections filed by the parties, then the right of appeal would stand nullified without any intervention of the legislature. In this context, reliance has been placed State of Karnataka versus Union of India and another. Drawing our attention to Section 31(4) of the Act, Mr. Rajesh would contend that the said provision is intended to deal only with those situations where, even after compliance with the first three subsections of Section 31, there may be two or more courts wherein proceedings under those subsections may be taken, but it has no application in those cases where a superior higher court has retained control and passed a direction to file the award in that court. The concept of choice as enjoined in section 31(4) has to be understood as courts of equal status. Learned senior counsel would further submit that the control of superior courts has to be given primacy